Members, we have a quorum. We've reached the appointed hour. Let's invite the officials in.
大家大戰過後仲未翻嚟，個魂魄未翻嚟。OK， 無論如何，即係大家打咗場好靚嘅仗嚇。係今日出席嘅。
Today we have the Deputy Secretary for Commerce and Economic Development, Ms. Carol Yuen, Principal Assistant Secretary, Mr. Sam Hui, and Senior Government Counsel, Ms. Melody Hui, attending our meeting. This is the meeting on the three orders in respect of the resolutions of the UN Security Council. In fact, the papers have been sent to members, and they are CITB CR 7553-9, the United Nations Sanctions Yemen Regulation 2015. The second one is CITB CR 9553-1, United Nations Sanctions Libya Regulation 2011, Amendment Regulation 2015, CITB CR 1316, 136-53-1, Legislative Council Brief on United Nations Sanction Côte d'Ivoire Regulation 2015. Would Ms. Yuen take us through the papers according to this order, please? Yes, thank you, Chairman. With regard to the United Nations sanctions, the regulations, they are made according to CAP 537, the United Nations Sanctions Ordinance, to implement the UN resolutions in respect of certain sanctions. On the 17th of July 2015, we gazetted 3 regulations concerning Yemen, Libya, and Côte d'Ivoire. And on the day of gazettal, the regulations came into effect immediately. Upon members, the requirement of the Council, on the day of gazettal, we briefed, we provided the paper to the Legislative Council Secretariat for members' reference. As suggested by the Chairman, I will follow the advice and then introduce first the UN Sanctions Yemen Regulation 2015. Yemen is in Western Asia, an Arab country. Since 2011, the UN has been providing help to Yemen for its economic political transition. But there were still challenges. Therefore, the Resolution 2140 was passed by the UN, and that includes trade, travel embargo, and other embargoes. And then the UNSC 2014 was further extended to the 26th of February 2016. There are also arms embargo as well. And then we receive instruction from the MFA for the implementation of 2204 and 2206 UNSCR. Therefore, on the 17th of July, we published the regulations in the Gazette. Since the trade volume is small, say in 2014, Yemen ranked 133rd among our trade partners. In total, trade was just $171 million. So the embargo or sanctions will not have any significant impact on trade. This is by way of the background. As for the regulation, Mr. Hui will go over them. Mr. Hui, would you please focus on this. Now, in respect of the things we used to have, say, with regard to funds, weapons, and things like that, are there any anything new? I don't know whether C is something new, and that is seize and dispose of, such as through destruction, rendering inoperable, storage, or transferring to a state other than the originating or situation or destination state for disposal. Mr. Hui, please. Thank you, Chairman. Just like previous meetings, we will go into the markup copy as the basis, so as to brief members on the latest Yemen regulation in comparison with previous provisions. As said by the Deputy Secretary, with regard to this new Yemen regulation, in terms of the sanctions, the major changes, the extension of the 2 areas of sanctions, including travel embargo and financial sanctions. And then under 2216 UNSC, there is also arms embargo. And so you can see the marked up copy. All the new things are for the purpose of implementing the arms embargo. It's Annex E, the markup copy. My apologies, Mr. Hui. Please go on. Let us go over this. Part 1, preliminary, and then clause 1, interpretation. That is a technical amendment. With regard to the numbering, we have made some changes. As for subclause B and C, apart from including the persons and entities, the relevant persons and entities, C, we've also added a person or entity acting on behalf of the entity. This is basically the formula of the UN sanctions in recent years. Other parts are similar. We've added a few items under interpretation, and they are designated persons, designated entity, arms or related material. They are to implement UNSC 2216 with regard to the arms embargo. This is to target at the persons and entities designated by the UN Security Council. We need to define these terms so as to comply with the sanctions arrangements and relevant provisions. As for the drafting approach, we just follow the existing drafting approach with regard to the text. In the interpretation, we've also added a few definitions for the implementation of the powers, and that includes the vessels, aircrafts. We need to conduct inspection or investigation. And therefore, you can see that in later provisions, there are similar concepts. And therefore, we have the definition for master and pilot in command. That's for interpretation. Any questions from members on interpretation? If not, please go on, Mr. Hoyer. Section 2 and Section 3 are the prohibitions. Sections 2 and 3 are related to embargo. And also, it is the prohibition against supply, sale, or transfer of certain goods. As for the object of sanction, they include those who directly or indirectly supply, sell, or transfer certain goods. And that also includes directly or indirectly supplying the goods to a certain destination for the purpose of directly or indirectly supply, sale, or transfer these prohibited goods to the designated persons or entities. So they will be in breach of the sanctions if they do so. These are usually adopted approaches. Now, if you have already adopted the normal or the model text, then you can just tell us that it follows the model text and there is no change. Then things will go more quickly. As for Section 4, is in respect of assistance or training, provision of assistance or training, as said by the chairman, we follow the model text. Any questions with regard to Sections 3 and 4? With regard to this Yemen regulation, do members have any questions? If not, then Ms. Hui, please go on. As for Section 5, prohibition against making available funds and or dealing with funds, we have just changed a bit of our drafting. Owned or controlled by. Owned or controlled. We have already explained that to you in the past. Yes, we did have a detailed discussion on this. The next is Section 8, which is also in respect of owned or control. It's also owned or control. The use of this term, owned or control. Any queries? Yes, please go on, Mr. Hoy. Then, Part 5, the enforcement of regulation against suspected ships and other means of transport, and also the provision of powers to deal with them. They are also in compliance with the text of authorization we used to have. The Part 5 includes Sections 11, Section 12, 13, 14, 15, 16, 17, 18, 19, 20. Part 5 covers all these. In fact, the subcommittee did discuss with the administration on such acts, powers, duties and responsibilities and conditions for exercising such powers. We've discussed that many times before. Can the legal advisor confirm that the wording follow the model text? Chairman, yes. I can confirm that they follow the previous regulations. Well, I just asked the legal advisor. I asked her to confirm that the wording of Part 5, whether it is in line. Yes, I understand. I've heard it. But for the first half, I have not heard it clearly because the microphone is not on. She just confirmed. I just confirmed that I've checked this against the previous text and they are the same. Part 6, please, Mr. Hui. With regard to Part 6, is said by the chairman, Sections 22 and 23 are not very common provisions. They are seized articles liable to forfeiture. This is put in because under 2216, UNSC 2216, there are similar provisions. In order to implement the sanctions, we need to authorize the magistrate or judge to deal with seized articles and to deal with forfeitures. As for the wording, in comparison with other UN sanction regulations, it doesn't. There are similar ones, but this one is new.
In other sanctions regulations, has mentioned that seized articles are liable to forfeiture. So this is not something new if we make reference to regulations vetted in the past. But I was asking the administration, must the seized articles be disposed of to another country or other than the source of origin? I'd like to know whether this is new. Yes, this is new. Where can we find it? We have to vet it carefully. When I say new, I don't just mean new to the Yemen regulation, but in all regulations related to other places. I'd like to know whether they have appeared in the past. In my memory, this is the first time we see it. That is, it must be disposed of by handing over to the source country or the destination. I believe it is. It can be found in other regulations, but I don't have it with me. Then it must be very rare. Yes, this is something rather uncommon. Can you show us the relevant provisions, please, so that we can scrutinize it more carefully? Then shall we start with Section 22? Yes, please, members, help to look at it carefully. Subsection 1. Within 30 days from the date of the seizure, serve notice of the intention on every person who has, to the knowledge of the officer. Well, this is the usual drafting. So it's found in other regulations on seizure and forfeiture. Subsection 2, again, this is a common provision. All right, for a period of not less than 7 days, commencing within 30 days from the date of the seizure. Okay. Subsection 3 is no different from other similar regulations. Subsection 4, the same. For subsection 4C, because these people, claimant, may not have a permanent address in Hong Kong, and where can we where does the solicitor comes from? Can you explain to us the procedures under 4C, subsection 22? Section 22, subsection 4C. Your question is, Chairman. I didn't quite get your question, Madam Chair, because what it means here is that if the claimant does not have a permanent address in Hong Kong, then the solicitor who is qualified to practice under the legal practitioner's ordinance can take certain action following. So if the claimant receives your notice, he has to find a solicitor in Hong Kong, and that solicitor has to be someone qualified under the legal practitioner's ordinance. What about the 7 days or 30 days periods? Will that be sufficient time for someone who has not a permanent address in Hong Kong to find a solicitor to act on his behalf? In other pieces of legislation, I'd like to know when we have the same person who has not a permanent address in Hong Kong and is subject to the same time restrictions. Yes. Yes, all right, then you've answered my question. Subsection 5? Yes, similar to the previous drafting. Okay, if there are no questions, Section 23. 23, Mr. Hui. power of magistrate or judge to make order for forfeiture and disposal. Subsection 1 is also a common text. All right. Any question? Subsection 2, please. Again, the same. Subsection 3 is the same. Subsection 4, the procedural requirements are just the same. So the summons is served to his local solicitor in Hong Kong. Right. Chairman, I was just discussing with my legal advisor. As I said, these provisions on seized articles and so on and so forth are not found in all related or similar regulations, but the way of drafting here is just the same. Indeed, we're not too familiar with this, so I'd rather proceed slowly to allow time for members to go through the provisions. Okay, Part 7. Part 7, disclosure of information or documents, no change. Part 8, we've added a new provision, and that is specification of designated persons or designated entity by Chief Executive. This is to facilitate the CE to specify a designated person or a designated entity by notice in the Gazette when there is a new UN resolution. Is this a new provision? Yes, but the way of drafting is our usual mode. I'd like to know where the power comes from. Is it by virtue of 2216(20)(d)? The designated persons or designated entity can only be specified by the CE under the resolution once it is designated by the committee, right? Yes, and that's the source of the seized power. So the scope of the seized power is subject to the resolution under UN. All right, any questions? If not, Part 9. Duration. The duration is until the 26th of February 2016 following the UN resolution. Okay, explanatory note. It's just to explain what the regulation is about. All right, do we have any follow-up questions on the Yemen regulation 2015? If not, we can go on to the next regulation for Libya. Ms. Yun, please. Thank you. Just to give you the background, Libya is a country in North Africa. In February and March 2012, passed a resolution 1970 and 1973 to cover a number of sanctions on tourism, goods, and also assets. In March and August 2014, resolution number 2146, 2176 were passed again respectively to impose sanctions once again for a year. And then in March 2015, 2011 resolution was passed again to extend Resolution 2147 for another year to the 31st of March 2016. We've received instructions from the Foreign Affairs Ministry that we must implement Resolution 2147. Since Libya only ranks 147 as a trading partner with Hong Kong, and the trading volume is only $100 million per year. So we believe the economic sanctions will not pose significant implications or impacts to Hong Kong and Libya. This is just to extend a previous resolution. I'll give the floor to Mr. Hui to explain the order to us. Yes, please, a marked up copy is in Annex D. Yes, please. I have attended several of these meetings, and every time the administration would tell us the trade volume and trade relations between Hong Kong and the country in question. Isn't it a red herring? Regardless of the trading volume or how significant the impact will be on us, we have no choice but to exercise the sanctions. It's not that we can refrain from imposing the sanctions if the economic significance is quite substantial. I know this is not what we mean. We asked for such information from the administration because we wanted the administration to know the number of people in Hong Kong affected so that they can inform local trading partners with the relevant country, and to let the council know the trades or industries that will be affected. It is in fact a checklist for the administration to approach the relevant trade associations or chambers of commerce, so that businessmen in Hong Kong will not be breaking the law inadvertently. When the subcommittee was first set up, we asked the administration to follow procedures, and the text should follow the sample text or model text as far as possible, so that even though LegCo has no power to amend the regulation, we can still monitor the executive in the enactment of laws. Mr. Hui. As the Deputy Secretary said, the regulation seeks to extend an existing sanctions regulation. So the text is almost identical to the existing one, with the exception of some of the updated resolution number of UN. Now, under Part 1, we have updated the interpretation section. So it's just technical in nature. Yes. Part 2, Section 3, an amendment is made to 1B and D. Instead of waters of the Hong Kong SAR, we say waters of Hong Kong. This has nothing to do with the UN resolution. Every time we draft the new regulation, we will check to see whether the terminology or wording is inconsistent with other regulations. And we find out that when it comes to the waters of Hong Kong, under Cap 1, we have a definition. Waters of Hong Kong is an legal concept in our statute instead of waters of the Hong Kong SAR. So we've taken this opportunity to amend the wording so that it can be consistent with other legislation in Hong Kong. So for other regulations, sanctions regulations, waters of Hong Kong SAR will be replaced by waters of Hong Kong. Okay. 3 capital A and 3 capital B of Part 2, they are scrapped and replaced by 3 capital C and 3 capital D. But members may see that 3C and 3D are identical to 3A and 3B. We need to amend or replace the provisions because of the new resolution.
This is also a technical amendment, right? Yes, in the same way, with regard to financial sanctions, 7A, 7B are deleted and replaced by 7C and 7D. They are exactly the same. And then 10A and 10B and 10C. They are dealt in the same way. They are replaced by 10DEF. The only thing worth mentioning is under 10F, apart from repeating the original words, with regard to prohibition against certain ships from entering waters of Hong Kong, we use waters of Hong Kong instead of water of HKSAR. This is also 10F brackets 3ABCD. And also the small title of 10F. Yes. As for clause or section 11 2C, though for airspace there is no Cap 1 definition, but for consistency with waters, we also change it to Hong Kong airspace instead of HKSAR airspace. Part 3, please. As for Part 3, there is no change. There is no amendments. They are the original provisions. And there is no change to Part 4. No, not at all. And then Part 5 is just to amend the numbering. Say 3A change to 3C. Yes, it's just for citation. Citation of the provisions. There are some changes. No change in Part 6 either. And no change in Part 7. This is an extension, and therefore it is simpler. As for Part 8, the only thing that has been changed is the date is extended to the 31st of March 2016, and also the numbers or the numbering has been changed with regard to the sessions or sections. So that's the any comments or questions on the UN Sanctions Libya regulation? If not, then we move on to Côte d'Ivoire. Yes, Ms. Yun. Thank you, Chairman. Côte d'Ivoire is a Western African country starting from 2002. It was in civil war starting from 2004. There were various sanctions. And the UN passed the 2219 resolution, which is to extend the arms and trade embargo, extending financial measures and travel ban until the 30th of April 2016. In May 2015, we received the MFA instruction asking us to implement fully the UNSC 2219. Therefore, we gazetted the UN sanction. As for the trade volume, the trade volume is rather small. In 2014, total trade is just $225.8 million. As for the types of goods exported or imported, they are not related to any arms. Therefore, the sanction will not have any significant impact on Hong Kong's economy. As for the details, Mr. Hui will go over them. Now I look at the notes concerning the imports from Libya. Cosmetics, perfumery, cosmetics imported from Libya. I find it strange. Note 9. Yes, the goods. They produce these things, and we import these things from them. Perfumery, cosmetics, or toilet preparations. Yes, according to the notes. They are imported from Libya. The quantity is not big. I'll ask you the brand after the meeting. That is beyond my imagination. Mr. Hui. Thank you, Chairman. With regard to the Côte d'Ivoire regulation, it is dealt with in a similar way as those of Libya's. It is just to update the regulation. The content is rather simple, therefore the technical changes or amendments are also simple. You can see that in the paper Annex D, the markup copy, in the interpretation section, the change is just to change the serial number of the UN resolution. When reference is made to the customs, the Director of Customs, we do not mention that specifically. And then the next change is Part 5, which is also about the serial number of the UNSC. Part 3, Part 4, no change. Part 5, there's no change. Part 6, no change, nor for Part 7. As for Part 8, Section 28 is also a change in the serial number. And then the effective date is extended by another year to 2016. Any questions? No? Okay, so it's a short meeting. We have studied the 3 regulations. May I thank members and thank the officials. I really will ask you what kind of perfume and cosmetics are they? Maybe you want to try. Okay, thank you very much. Meeting is adjourned.